I think, Lord Denning, it would be good now to talk about the procedural controls which the courts have worked out, as opposed to their controls of the substance of what ministers and governmental powers do, which we talked about in the context of abuse of power. But this opens up the subject of natural justice. And I think perhaps it might be a fair comment that the turning point came, which brought about such a great change in the whole attitude of the judiciary to administrative law, round about the time in 1963, when the famous case of Ridge and Baldwin was decided by the House of Lords. And I think perhaps that was one of the very few notable decisions in this era of progress to which you made no personal contribution.
Well, I can tell you why. When it was in the Court of Appeal, I was in the House of Lords, so I didn't sit in the Court of Appeal for it. When it came back up in the House of Lords, I was back in the Court of Appeal, so I couldn't sit in either part of that important case. I agree with you. It is a landmark case, not only on the revival of natural justice, but onto the matters into which the courts could inquire. Let me tell you, well, perhaps I ought to remind you, the Chief Constable of Brighton was tried and acquitted because there were charges at that time of bribery amongst the police force of Brighton, but other police officers were convicted. And the judge, Mr. Justice Donovan, he said, well, you're convicted. In effect, he said, that chief constable is lucky to be acquitted. He didn't use it in those words, but on the other hand, that's what he said. And upon that, the Watch Committee of Brighton dismissed the chief constable without hearing what he had to say. Now, there was the crucial point. Natural justice was not done. One of the fundamental principles of natural justice is the right of a man to be heard in his own defense. And that was what the chief constable was not afforded. So they were quite right, in the House of Lords, if I may say so, quite right to upset the case and hold the dismissal was void. But I ought to tell you the trouble, why the Court of Appeal decided the other way, was this, that in those days it was said the courts could inquire into matters which were judicial or quasi-judicial, but not into matters which were administrative. That had gone back to 1951, a case before Lord Radcliffe, or 1950, before we started all this. And so the Court of Appeal thought they couldn't go into it. But the House of Lords, and this is the important point, I think, on that case, held that we could inquire not only into judicial acts, not only into what is quasi-judicial, but also the administrative acts of ministers and their lackeys. And I ventured to point that out in a case afterwards about the gaming board and so on, but that was the important point. A procedure, if you like, but we could now inquire not only in judicial acts and so on, but also into the administrative acts. That was the great breakthrough, as well as to see that natural justice was done. That's the importance of that great case.
That was an extraordinary judicial fallacy, if I may say so, that the judges seemed to be addicted to for many years, because you don't find it in the old cases. You can go back to the 17th century and find the courts dealing with cases of administrative action, usually by the justices of the peace, who had all the administrative powers, such as there were, in their hands in those days. Why do you think it was?
Well, because in 1923, that was one of the nadirs, the lowest points, Lord Justice Atkin in a case talked about acting judicially, and then Lord Hewitt himself had elaborated that, and from that time onwards it was thought the courts could never interfere except when it was judicial. And the great breakthrough in Ridge and Baldwin was to say they can interfere with administrative acts also. And that is, as I say, it's a landmark in our law. That's why we could interfere after Ridge and Baldwin.
So there seemed to be a kind of connection between natural justice and acting judicially, as if these were synonyms.
That was thought in the old days. Natural justice applied to judicial acts, not the, but now we've altered all that. That's one of the great alterations, and we've had time to stress it time and again since.
But the judges seem to make so much heavy weather over this that they had to invent a way of escape by an entirely different route, which they called acting fairly.
Ah, yes, that was Lord Parker. Lord Parker, you know, had been on Lord Franks's committee on administrative tribunals, and of course I took a great interest in that. Indeed, it resulted in the Tribunals Act. I took part in the House of Lords in the debates on it. Well, Lord Parker, I remember he told me about it at the time. There was an immigrations case where the immigration authorities had refused a youngster admission because they thought he was over 16. Whereas his father and all the people said he was under 16, he was only 15. Well, it was an administrative decision. The immigration authority said it couldn't be inquired into. And I remember Lord Parker talked over with me at the time. And we realized it was a very important case. He'd held that inquiry, and he said, well, I think they have a duty to act fairly. And that one sentence, a duty to act fairly, in a way, was a way of saying indirectly they've got to do natural justice. And, oh, I've cited it 100 of times since that VHK. It was really quite an advance, but it was done quite informally. I remember he talked over me going to and from lunch.
But it was a funny thing, don't you think, Lord Denning, that that case about the young immigrant was decided by Lord Parker under a complete misapprehension, because it was a few years after Regent Baldwin, and Regent Baldwin was never cited in the divisional court. They cited the Nakuda Ali case, which had come from Ceylon at an earlier stage to the Privy Council, and was a notorious example of denying the right to a fair hearing in what you might call the bad old days. And Lord Parker invented this way of sidestepping the issue about judicial or quasi-judicial by saying, oh, there's always a duty to act fairly, supposing that the old bad decisions were still authoritative.
Well, I don't know what he thought. I don't know about Regent Baldwin, I should have the mind, but I no doubt he was influenced very much by all the evidence he'd heard on his inquiry, and I know he spoke to me and he realized he was doing something new and important, the duty to act fairly. There's a case of a taxi driver, Lord Goddard had it. A taxi driver, they withdrew his license. They said he'd done something wrong or something of that kind. They didn't give him a hearing. And Lord Goddard said, oh, in these sort of licensing cases, taxi driver's license and so on, disciplinary cases, we don't have any inquiry into that. We don't inquire whether it's fair or not. Disciplinary cases are a line on the... And that ran the line for several times about licenses. But we've overcome that, I think. We overcame that in a case which all the youngsters like, about the street trader at Barnsley. Ever heard into the Barnsley market?
Mr. Hook?
Mr. Hook, and he'd gone, you know, into the yard afterwards to relieve himself, a call of nature, when it was all empty. And the head man of the market manager said, you can't do that here. And Mr. Hook said, oh, you be off.
Let's put it that way.
For that he was brought up before the committee. His license was taken away, whereas his living was dependent on it. He came before us, if I may say so, and we upset that committee. We said that Mr. Hook was going to continue to have his license. So we have continually, since those early cases, inquired into licenses, whether if they're to be renewed or if they'll be refused. Then the inquiry has to be fair. They are to be heard. The side of the case is to be heard before their license is taken away, or before it's refused to be renewed.
Wouldn't it be more true to say that you held that he couldn't have his license taken away without a fair hearing?
That's right.
Without saying whether or not they could take his license away, but the procedure...
Fair oh, yes.
He's got to have a
fair hearing and legitimate ways of doing it. When he couldn't take it away, there had to be fairness in all the procedure.
That brings out the enormous importance of procedure as opposed to the merits of the decision. And one feels very often there's such a temptation on people who have power in their hands to use it in the way that they think is right and best, and may be for the best, but without stopping to think of the other man's point of view.
That's right. That is the important thing. They think we are right about this. They don't stop to hear his side of the case. That's what happened in Baldwin and in the others.
You mentioned the gaming board case.
Yes, well, the gaming board asked the police, did you know anything about these people who are applying for licenses? And the police gave them information as to what they knew. And the question, and they did tell the gaming board, and upon that they were refused licenses. Well, then these croupiers complained about that. They said that the gaming board was acting on the information of an informer, and they ought to be able to see the information. It was quite unfair. Well, in that particular case, and it's a case with informers to the police and so forth, the accused man, he can know the generality of the case against him, but he can't go into those details. Otherwise, you'd never get people to give information. At all events, there's a sort of line one has. One was dealing with it fairly, but the accused person wasn't allowed to go into actual details to know what the police had against him, but you can know the generality of it.
This brings out the point that it's a matter of substance. And if there is a fair deal in the sense that the man on the mat, the accused, knows the substance of what is held against him, he doesn't have to see the exact words or reports or know where they came from in order to have a fair opportunity.
In other words, in each
it.
case it's weighing the balance. Natural justice isn't a thing you can lay down by metes and bounds. You have to consider the individual case. We've said it 100 times. But in that particular case, if the police were bound to show all their reports to the gaming board, you might get no one giving information. The same with a man who informs the police. We've always said the police needn't give the name of the informer, otherwise you'll never get people to give information.
And so you managed to effect a compromise whereby the person concerned with the license can be treated fairly, and yet at the same time the police source of information can be protected.
That's very much, all these cases are a question of balance to see where fairness in administration and procedure lies.
So natural justice does not go to the extent of a complete right of confrontation and cross-examination.
Oh, no, it depends on the individual case. One has to be very careful about that. We've had very many cases. Well, we had a case before Richard Baldwin, a police officer in Malaya. They thought that he was framing the witnesses, so to get a prosecution and get conviction. Well, he was charged, but they didn't show him the secret report which they had before them themselves, so he didn't know the case he had to meet. And that's another element of natural justice. The person who's charged must have a fair opportunity of knowing the case against him. And so we upset that case. It's Inspector Khaida. I may tell you afterwards, we let him free. He became a barrister of Lincoln's Inn, went out to practice in Malaya and did very well.
But doesn't it lead to a difficulty when a judge has before him a case, or perhaps a tribunal, where the license holder, or whoever it may be, has committed all kinds of obvious offences and misconduct? And then they say, take his license away. And they don't think to give him a hearing. They're probably quite right, or might well be quite right in substance, but have gone wrong in procedure. And judges don't seem to like then saying, well, you've gone wrong in procedure. The whole thing must be quashed. It must all start again. And they've had to invent one or two arguments for refusing fair hearings in that situation. I think you'll see where I'm leading.
Well, I don't know where you're leading to a case which the youngsters in the universities often ask me about. That was of the student at the university, a teacher's training college, a girl student, and contrary to all the rules and regulations, she had a man in her room every night for 3 months on end. and she was disciplined. The governing body said that was contrary to the rules, and they couldn't have this, and she could no longer be a teacher. Well, she went before the body, whoever it was, to decide it. I forget what it was. Someone who was there, some inspector, whoever it was, who really oughtn't to be there. And she challenged the decision on that ground. Well, I think that in a way, on procedure, she was right. Well, we may have been wrong, but we thought, well, this girl had broken the regulations, she oughtn't to be a teacher anymore, and we stretched the point. Although the procedure was a bit wrong, we upheld the decision. You're quite right. That gives an illustration that judges are tempted, if the decision they think was right, not to interfere on a mere ground of procedure.
Now, didn't you yourself invent, if I may put it that way, a pretext for not giving fair hearings in the doctrine of no legitimate expectation? You had a case about Scientologists.
Oh, well, now that's quite an interesting... You know, a lot of these cases were argued by the present Lord Chancellor, Mr. Hogg, as he was. That gaming board case was, and this Scientologist case was. Well, that was a case where at one time, you know, the Scientologists were looked very much frowned upon by the government, by the Home Office and everybody. But they had a big institution at East Grinstead, where they run their courses for students and so forth. Well, one of the students came from Holland. She came here on a license to study and be there. They gave her the license, and after she'd been here, she wanted it renewed. And they refused to renew it. They thought she'd been here long enough. Well, the argument was, well, they were wrong to refuse it. Although there was this policy against Scientologists, they were wrong to refuse her the extension. Well, then I said, I think it may introduce a new, I said, it all depends. She hadn't got a right to be here. Had she had a legitimate expectation to be here? If she had a legitimate expectation of it being renewed, it ought not to be taken away without a hearing or all this other. Well, in that particular case, we held, the policy being against Scientologists and everything of that kind, she had no legitimate expectation. But that phrase of mine, legitimate expectation, has come, I don't know whether it ought to be come into the law. You might, even though a person hasn't got a right, if she has a legitimate expectation of something, a renewal license or whatever it may be, there's got to be a fair hearing, and justice has got to be done. That's the way we extended the right to interfere with people who didn't renew licenses and so forth.
To deal with unmeritorious cases where there were really no merits at all.
Well, of course, I don't know whether you remember that case we had at London Airport.
The minicab.
Cinnamon, you remember the name. You remember the name.
Cinnamon.
I remember a lot of these taxi drivers were charging enormous fares, you know, for the people from Heathrow into London. And there was no way of catching them. Some of them were convicted, they'd pay the fines, and still they'd go on, or everything like that. And the question was, and then upon that, the airport authority said, well, these people who've been continually convicted and fined, the only thing we can do is to disallow them and not allow them to come into Heathrow Airport. They charge these enormous fares. But I don't know that they had a full hearing. But the result was plain. They would be convicted, they'd been fined, they disobeyed the fines and everything of that kind and disobeyed the rules. Well, we said there's no need for a fair hearing here. It's quite obvious that these men ought not to be. The only thing to stop them is to give an absolute order prohibiting them from coming. And we held that order by law was absolutely right.
But don't you think that's a dangerous argument? That because somebody has obviously got no merits, he ought not to have fair procedure. It's rather like saying that because you've seen somebody knock down somebody and kill them, he oughtn't to have a fair trial.
I quite agree. I think it has dangers. I don't know whether we stretched a point there. But one does in the ordinary practical administration have to's and fro's. One has to stretch points occasionally. We don't go by rigid rules. I'm sure we were right upon that case. There was no appeal to the Lords. It was the right way of handling it. But you see, well, in all these cases, not a professor sitting in his study, but the judge having to decide the case. he's influenced by the sort of general look of the case. What is the justice in this particular case? The justice of that case was that these taxi drivers who'd been exploiting the public all this time should no longer be allowed in London Airport, and that was right.
What do you think about students?
Students?
Who misconduct themselves and get removed from their universities. There was one young man, I think it was a man and not a woman, who exhibited himself nude on the campus at one university and was
you know much more about this than I do.
Sent down by the Vice-Chancellor. And I think it was Mr. Justice Pennycook who held that since he'd obviously misbehaved himself and hadn't a leg to stand on, that there was nothing wrong in sending him down summarily without a hearing to speak in his own defense.
Oh no, I think he ought to have had a hearing there. Of course I don't know there should be a hearing when a student complains he's been wrongly failed in his examinations. I've had that, or he ought to have been given a degree and he wasn't good. In some of my other capacities, I was the president of Birkbeck College, and I was a visitor of it virtually. And then a student who didn't get his examination or didn't get his degree, he said, I ought to have got it, and he wanted an appeal. Well, we can't have that. In other words, there's some spheres in which we don't operate. But in cases where it's misconduct, such as that being nude or whatever, or the case which I had of the student teacher who was dismissed, all those, there ought to be a fair hearing.
Well, I'm comforted to hear what you say about examinations, at any rate.
Well, I don't know, but I know, but I've had that in practice. A lot of them want to say, well, I want an appeal.
But the case I mentioned lets in that dangerous argument that since it wouldn't have made any difference if he had been given a hearing, therefore there wasn't any need to give him a hearing.
It's rather like our taxi drivers at Heathrow.
What do you think about the question of the duty to give reasons? Isn't it one of the great weaknesses of the principles of natural justice that they don't extend to an obligation to give reasons for decisions, except, of course, where the Tribunals and Inquiries Act introduced a special provision about this? But don't you think it ought to be part and parcel of the principles of natural justice?
Well, I think if you go back to that committee in 1932 our ministers passed, they thought that giving of reasons was one of the elements of natural justice. And I've said so. I said in some of those early tribunal cases that they ought to give reasons. I think I said in Padfield, they ought to give reasons. If they don't, it's to be inferred they had no good reason. Or alternatively, if the courts can order them to give reasons. That's what I said in the oldest, and I think I said it. There was quite an important case on the pensions appeals called Gilmore years ago. And I remember we developed the law quite a lot in that case as to whether you could interfere with the medical appeal tribunal. Well, I said they ought to give reasons. No, I think reasons should be given because, you know, to give reasons clears your mind. I don't know whether you notice in a way, but I always found that in writing a judgment, I might change my mind because I had to put it into writing, had to give you reasons. And having makes you clear your mind a good deal, you know, and so it can't, if I may put it, it concentrates the mind wonderfully to have to give your reasons. And another ground for giving reasons is to give satisfaction to the party, to know why he's lost. But also if there's an appeal or inquiry by the courts know on what ground it proceeded. No, I'm inclined to agree that the giving of reasons is one of the elements, or should be one of the elements of natural justice. But don't carry that too far, you know. Our magistrates up and down the country give their decisions without giving reasons. You know what Lord Mansfield once said to a new colonial judge? Give your decision, but never give your reasons, for your decision may well be right, but your reasons are almost certain to be bad. But there we are, no, but I incline to think, and all the new tribunals, you know, whether it's the industrial tribunals or whatever it may be, often by statute they're required to give reasons. And those are a great help to any appellate court. And I'm inclined to think that the giving of reasons should be generally recognized as one of the elements of natural justice.